Hi, and welcome to this latest immigration law conversation video. Today, I'm joined once again by Danai Papachristopoulou, and I hope I've pronounced your name well, Danai. I hope I've started on a good foot. Today, we're talking about something that we've both had a recent experience of issues coming up, and that's settlement applications for children and young adults under the Appendix Private Life. Now, for those of you joining today, Appendix Private Life came in June 2022, replaced the previous private life rules, and replaced the concession for young adults for early indefinite leave to remain. So just before I go through the rules, what I'm going to do is I'll run through the rules, then Danai and Ali will have a conversation. But just, Danai, this is something that's been coming up a lot for you at the moment.
Yes, a lot of people are trying to, a lot of our clients know about the new rules. They want to see if they can benefit from. So we have a lot of people that could potentially be eligible. Some of them are, some of them maybe. So yes, definitely.
Cool. Let me share my screen and I will put up the rules in Appendix Private Life. Now, we're not going to go through all of those today. We're focusing specifically on settlement application. So I'm going to roll through the rules here and I'll pause when it comes to settlement applications. So we're particularly going to look at problem areas today. So settlement on the private life route starts at Rule 11, so PL 11. So if you look at PL 11.1, it says a person on the private life route who's applying for settlement must apply online on the gov.uk website on the specified form as follows. And the two forms for settlements, one for adults, one for children, are specified. And what I'll do in the description to this video, I will put the links for those forms and the general leave to remain form for Appendix Private Life in the description for people to see. Now, do check those sometimes those links and those forms change over time. PL 11.2 sets out that a fee must be paid, biometrics must be done, passport or travel document must be provided, and the applicant must be in the UK. We're not going to dwell on those matters. Then 11.3 is important, and I'm sure Danai will come back to this in a minute. 11.3 says an applicant must have or have last been granted permission on the private life route unless they are a child who was born in the UK. And we'll come to the separate rules for children born in the UK, although we won't spend a lot of time in this video on those individuals. 11.4, an application which does not meet all the validity requirements for settlement on the private life route is invalid and may be rejected and not considered. So these are validity requirements. Then there are the suitability grounds. We're not going to spend any time looking at suitability today, but please be aware of the suitability grounds. Then PL 13 deals with those children born in the United Kingdom. So 13.1, applicant must be born in the UK, must provide a full UK birth certificate. 13.2, the applicant must have lived continuously in the UK since their birth and for at least 7 years at the date of application. The decision maker must be satisfied that it is not reasonable to expect the applicant to leave the UK. So favourable rules for children who've been here 7 years and were born in the UK, they can apply after 7 years as long as you can show it's not reasonable for the applicant to leave the UK for immediate settlement. Then 14.1, we are going to spend some time on this, which is the qualifying period requirement for settlement on the private life route where the applicant was not born in the UK. An applicant who has or last had permission to stay on the private life route as a child or young adult who met the half the life test under PL 4.1 must have lived in the UK for a continuous qualifying period of 5 years with permission as set out in PL 14.3 or 14.4. So somebody who has or last had permission on the private life route as a child or young adult, settlement after 5 years, and they can combine leave as set out in 14.3 or 14.4. But I'm sure Danai will come back to the important point that they must have or last have had leave under the private life route, which is an anomaly of the rules. An applicant who is aged 18 or over at the date of application and does not meet the requirement in PL 14.1 must have lived in the UK for a continuous qualifying period of 10 years with permission set out in 14.3 or 14.4. So children and young adults, 5-year settlement, others 10 years. Then 14.3 sets out the following routes which can count towards the qualifying period set out in 14.1 or 14.2. And that's entry, clearance, or permission granted as a partner or parent under Appendix FM. Permission described in the Home Office grant letter as family permission as a parent or family permission as a partner. Permission on the private life route under paragraph 276 ADE or 276 BE2 before 20th of June 2022. That's when the new rules came, or Appendix Private Life. Entry, clearance, or permission as a child of a person with limited leave as a partner or a parent under Appendix FM, or permission granted outside the rules as a partner, a parent, or a child because of private life on the basis of Article 8 of the Human Rights Convention. And then 14.4 sets out that you can rely on other routes which qualify towards settlement that are not listed above, provided the applicant did not enter the UK illegally and has had permission either under 276 ADE or 276 BE2 before the 20th of June 2022 or Appendix Private Life for at least 1 year at the date of application. So stricter requirements when relying on other routes that are not set out in 14.3. 15.1 sets out the continuous residence requirements as set out in Appendix Continuous Residence. We're not going to look at that today, and we're not going to look at things like the English language requirement or the knowledge of the life in the UK requirement for settlement on the private life route. But do be aware of that, because some people remember the old concession for early ILR for young adults, which you didn't need the English language requirement or the knowledge of life in the UK. So just be aware of that. Now, that's been a bit of a tortuous tour through the rules, but Danai, in terms of issues, I think 11.3 and 14.1, which is up on the screen, have caused issues. What issues have you encountered in the light of these paragraphs?
So the main issue, as you've already said, is that both these provisions require the applicant's extant or last leave to have been specifically granted under the private life rules. So it's not whether they met the requirements under private life, it is whether the decision letter that they have on their previous leave says private life rules. And in our experience, many decision letters don't say private life rules, even if the applicant met the requirements under private life at the time of the previous application. So it's worth pointing out that as you mentioned, these provisions on early settlement were incorporated into Appendix Private Life following a concession that the Home Office published in October 2021, which was published following litigation that happened. So the main principle underpinning this concession was that the applicants who were either born in the UK or arrived in the UK as very young children cannot be considered responsible for non-compliance, for previous non-compliance with immigration rules, because that was obviously their parents' responsibility. And they are also fully integrated. So it's not proportionate to expect them to complete 10 years of lawful residence before they are able to settle. And instead, they should be able to settle after 5 years of lawful residence. And the concession didn't have anything about the specific leave that you're currently on when you're applying, as long as the requirements were met in essence. So that the drafting of the current appendix is a departure of that concession. And in our experience, there are many children and many young adults that were previously part of family applications They met the private life rules, but they were making one application as a family, and then the decision letter came and said, leave as a child under Appendix FM, leave as a dependent, or sometimes leave based on family life, sometimes discretionary leave. We have seen decisions from the Home Office, and sometimes they're not exactly accurate. And these people won't be able to benefit from the early settlement provisions because they don't meet PA 11.3 and PA 14.1 because their current leave is not granted under the private life rules.
So are you saying they would have to make an application for leave under the private life rules first before they could apply for settlement?
Well, technically, yes. Technically, they don't meet these requirements.
Yeah,
so
absolutely.
the safest option would be you switch to the private life route. And once you have the decision that says private life rules, and you meet the other requirements for settlement, you make an application for settlement. But of course, that means time and also money. Yeah. And let's not forget that the application fees have just increased, and the IHS is increasing for a further leave application is increasing on the 6th of February. So that it's unreasonable to expect people to just do this extra application when they should just meet the rules. But that might be the safest option. Another thing that we have done is we have cases where we wrote to the previous decision maker and asked them to change the decision from maybe 2.5 years ago to reflect that the leave should have been under private life rules. We have been successful so far. I don't know if all of them will be successful, all these efforts, and this is not, this is not something that is in the law. But also the other issue with this is it's time consuming. They get back like maybe in a month or two, and usually these applications have a deadline. So you don't have the luxury of actually doing this and then giving the advice to your client or applying.
You're going to have to protect your client's leave and not leave your client as an overstayer, which then might cause problems with future applications.
Yes.
Did you say the caseworkers have got back to you in about a month, did you say?
I think the last one took 2 months.
Right. Wow. Yeah.
So I'm very aware that you don't have, unless somebody is like preparing way in advance and we have this time to say, let's write to the Home Office, let's see if we can do this. Otherwise, when the deadline is in 3 weeks or 1 month, you can't do this.
And the safest option, as you've said, would be to apply for leave under Appendix Private Life. Let's take this step by step. Once you get the leave on the private life route, do you have to have it for a certain length of time before you can then make the second application for settlement?
So it depends on the 5 years of qualifying period that you rely on. If it is one of the routes that are described in PA 14.3, then no, you can do it immediately as long as you meet suitability and the rest. But if any part of the 5-year qualifying period falls under 14.4, so it's not included in 14.3, but it's a different route that still leads to settlement, then you will have to have it for a year.
Wow.
For extra delay.
No, absolutely. And just, have you ever done any cheeky requests in any applications for leave to see if you can push to get indefinite leave? Again, we're not giving advice at this stage, and the safest course, absolutely, as the rules currently stand, is to make the application for leave first and then the second application for indefinite leave. Have you had any when the Home Office have sort of exercised discretion and granted your client ILR straight away?
We did. We had instructions from a client that wanted to apply for settlement. We explained the law, and they said, I just want to try it. I don't want to wait for 10 years. So we tried it very cautiously. We got a minded to reject kind of email that you don't meet the requirements. And then we made representations in detail about the issues that we're discussing now, and also about the fact that the Secretary of State has the power to grant it by discretion. And we were successful. But as you say, this is not something that we advise people to do because it's not the way to go. But we have been successful, and we know anecdotally from other colleagues that some of them have been successful after pre-action protocols as well. But that's not, but clearly, if you need a pre-action protocol, in my opinion, to get indefinite, there's something wrong in the way that the law has been drafted.
Absolutely.
So having said that, we are doing some policy work with ILPA. We have received also funding from the Strategic Legal Fund to do this policy work. So we are one of the organizations that are working with ILPA. And we are looking also, if the policy work doesn't work, what else we can do to make sure that either there is a change in policy or a change in the drafting of the rules to allow these children and young adults that should be eligible to be eligible without having either to risk a settlement application being rejected with the consequences that this brings, or having to apply for further leave and waste time instead of benefiting from the early settlement provisions.
Would you, because of the policy work you're doing with ILPA on behalf of the Refugee Migrant Centre, would you welcome representatives who've got these sort of issues reaching out to you with examples?
Definitely. Yes, definitely. Because we have based it on our case studies so far, everything that our feedback, and obviously ILPA has feedback from other organizations as well. But yeah, anybody that has seen that, it would be great if we can discuss it.
Yeah, Danai is the Immigration Department Manager at the Refugee Migrant Centre, and I'll put her details and the Refugee Migrant Centre details below this video. It was just occurring to me, perhaps as we were talking, when you talked about contacting the team who'd granted the previous leave and asking for it to be amended, I suppose if you ever had to make an application for leave to remain, if they did subsequently then amend it, I suppose if a decision hadn't been made, you could then vary that application to a settlement potentially.
Yes, you could.
This does get very, very messy, doesn't it? And this is what we want to try and avoid. And this is the difficulties with these provisions. And I know you've had experience and I've had experience with people making the wrong applications for clients, either thinking the old policy still applies or applying on a family life basis where they should be applying under Appendix Private Life, but perhaps haven't realized that their clients, because of 11.3 and 14.1, need to get leave on that private life route first. Just before we finish, are there any other sort of practical difficulties or steps you think people should take, or things people should be aware of?
I think one thing I want to say is that there are progressively so many different application forms, especially for children that could be eligible for settlement. We have Set O. If it's long residence, we have Set F. Under Part 8, we have Set PL. We have settlement under family life. And this is very confusing for applicants, but also sometimes for the legal representatives as well, to make sure that they use the correct form. And unhelpfully, the Home Office, when they do send these emails, and they either say, you haven't used the correct form, but they usually say you don't meet the requirements, and they don't help out the applicant on what form should be used, especially when sometimes the only error was the form. The requirements of a route are met. It was just the wrong form. So I would just say, be very, very careful before you submit an application. Check the law to see if the specified form is mentioned. Check the guidance and check the form itself to make sure that the form that you are using is the form that you want to use based on your clients or your individual circumstances, and you meet the requirements, and you don't have any emails from the Home Office saying you don't.
Yeah, so it's a question of checking that the form is the correct form applicable to this route and the route you want to apply under, and then making sure, as we've said, your client does qualify for settlement under that route because of the requirements of Appendix Private Life, which at the moment is perhaps more strict than the concession was, or be more restrictive because of this requirement to have leave under that route first, unless you're one of those 7-year children born in the United Kingdom, which is a separate category. Danai, that's really helpful, and I think really practical stuff there. Just thank you again for that. I'd encourage people to reach out to Danai if you've got case studies where there's been particular issues surrounding this. I'll put Danai's details below this video because this is something where the rules need amending and need changing. But until they are changed, I think it's Danai, to just repeat what Danai said, to make sure you're using the correct form and you do fulfill those requirements for your client. And maybe if you have got those clients who perhaps are coming up towards being eligible for settlement, but may have been granted leave as dependents of their parents under Appendix FM, see if you can get that letter corrected now, which will facilitate the indefinite leave application in the future.
Yes. And if you get new letters, because they continue, some of the grants continue to be wrong even now, if you do get letters that are wrong, just make sure you immediately ask for them to be corrected to preserve this right to early settlement in a future application.
Yeah, that's really helpful, isn't it? So if somebody's applying for leave now, they want leave under the private life route, and we haven't covered leave to remain and the fact people can select 30 months or the longer period and all that. Make sure when you do get that grant, it is under the correct provision, because you've got to think for the future now because of the way this is structured.
Exactly.
Brilliant. Danai, that's so helpful. Thank you so much again for your time.
Thank you for having me, Adam. Thank you.